75K. In any child custody proceeding in the state, the court shall preserve at least until the child reaches the age of 18, pleadings, orders, decrees, records of hearings, evaluations, and any and all pertinent records. First pleading, under oath, and it's the first pleading or attached affidavit, must contain the present address of the child, the address where the child has lived for the past 5 years, the names and addresses of the persons with whom the child has lived with for the past 5 years. So it has to contain all of those 3 things, and then there's other stuff that it has to contain to the extent information available. So a court of this state, which has jurisdiction to make a child custody determination, a court can make a finding of inconvenient forum. And if they do make that finding, it can be on the court's own motion, the motion of any party, or the motion of the child attorney or the child, or even the request of another court. Now, if the court does make a finding on inconvenient forum, it shall stay the proceedings to allow them to file another pleading in the appropriate forum, the other state. Okay, so next I want to do this one. So in the DRL, to register a child custody determination issued by a court of another state, the following are required: 2 copies of the determination, 1 which must be certified, 3 a letter requesting registration, 4 a statement under penalty of perjury that to the best of the knowledge and belief of the person seeking registration, the order has not been modified, and 5, with certain exceptions, the name and address of the person seeking registration and any parent or person acting as a parent who has been awarded custody or visitation in the determination sought to be registered. But this one is the sworn statement they're talking about is that it's not been modified or vacated. The one for the financial thing, it's just about their arrearages. It's the sworn statement they're looking for. Okay, so this question, I did not know this question, so hopefully this video will help me remember it. 77G, upon the filing of a petition for a child custody determination under UCCJEA, the court shall issue an order directing respondent to appear with or without the child at a hearing within 3 court days. 3 court days. 3 court days. For the UCCJEA, the court shall issue an order directing respondent to appear with or without the child at a hearing within 3 court days. Now, 75B says DRL does not apply to what? Now, it does not apply to an adoption proceeding, a proceeding pertaining to the authorization of emergency medical care for a child, to JD, a PINS, emancipation, support, or financial issues. Okay, it does apply to a decree made in a foreign country. Now, what it also does apply to is in any action for divorce, separation, neglect, protection from DV, guardianship, abuse, paternity, dependency, or termination of parental rights in which the issue of physical custody, legal custody, or visitation may appear. That's what it does apply to. What it doesn't apply to is this list of 6, which is adoption, emergency medical care, JD, PINS, emancipation, support, money stuff. Okay, so petitioner in 77 means a person who seeks enforcement under the Hague Convention on the civil aspects of international child abduction or enforcement of a child custody determination. So it means either of those 2 things. Either a person who seeks enforcement under the Hague Convention or enforcement of a child custody determination. 76H. If the information required in a first pleading is not furnished to the court on its own motion or on motion of a party may, and the only thing they may do is stay the proceeding until information is provided. They may not dismiss. They may not adjourn. They must stay, even though it says may. When you're only allowed to may do one thing, Yeah, it kind of means must. 77D, a child custody determination issued by a court of another state may be registered in this state by filing in part a letter or other document requesting registration, 2 copies including 1 certified, and a statement under penalties of perjury that to the best of the knowledge and belief it's not been modified. A person seeking to contest the validity of a registered order must request a hearing within 20 days after service of the notice from the court that an application has been made to register the determination. And that's the same as in the 5B. You have to request it within 20 days. Except as otherwise provided in 76C, a court of this state has jurisdiction to make an initial custody determination only if 1. This state is the home state of the child on the commencement of the proceeding, or it was the home state within 6 months before the commencement of the proceeding, and the child is absent from this state, but a person or person acting as a parent continues to live in this state. A court of another state does not have jurisdiction under paragraph A, or the court of the home state has declined to exercise jurisdiction on the ground that this is the more appropriate forum, and the child's parents or the child and at least one parent or person acting as a parent have a significant connection with this state other than mere physical presence, and substantial evidence is available in this state concerning the child's care, protection, training, and relationships. C. All courts having jurisdiction have declined to exercise jurisdiction on the ground that this is a more appropriate forum, or no court of any other state would have jurisdiction under the criteria specified in A, B, or C, and that's the example I used where they all just moved here from Australia, then they break up, and now they got to make a child custody determination. Okay, so